Jamaicans for Justice, the Police Service Commission and another.
My ladies and my lord, I appear with my learned friend Mr Dale. My learned friends Miss Malahoo Fort, Queen's Counsel, the learned Attorney General, and Miss Jarrett appear for the respondents in this appeal. Can I thank the court firstly for its very kind response to my letter. Turning then to this...
Be as comfortable as you wish, Mr Southey. It's entirely up to you.
Yes, I at the moment feel perfectly comfortable in this, but that may change, and I will have no hesitation in sitting down if I need to. This morning, what I propose to do, if I may, is firstly address relatively briefly the facts, then, perhaps more importantly in some senses, address the nature of the right to life safeguarded by the Charter of Fundamental Rights. And obviously we argue, or the appellant argues, that that has implications for promotion decisions. Thirdly, address why we say the Charter and the rights that we say that flow from it has implications for the Police Service Commission, and in particular why it has implications for its decisions in relation to promotion, and then finally address the common law. However, before doing that, I probably ought to say a little bit about the note that was served on Monday, which I suspect the court has seen, I assume the committee has seen. Obviously, the appellant is pleased that it is said that changes have been made. However, and submit it probably isn't of the greatest relevance, but however, we should firstly sort of enter a note of caution. It does remain the position of the appellant that there are significant problems with the complaints system in Jamaica. We handed up this morning 2 reports from Indicom. The second is just the most recent one, just really out of a sense for completeness. But the more important one is the annual one, which is the one that has on the face of it 2017, the year in review.
So I'm not sure that I've received them.
Oh, sorry, I thought they'd been circulated. They're on the side, sorry.
No, we'll get them in due course.
Yes, we'll get them in due course. Can I just get, I'll give the reference for the moment. I don't think we need. Page 41 of it notes that Indicom essentially is critical of the Police Service Commission for its lack of action following Indicom reports. So we would submit there are issues that remain in practice. More importantly, in any event in our submission, what is said in the note in our submission certainly doesn't make the appeal academic. The judgment of the Court of Appeal is binding precedent, essentially, which concludes that there is no legal requirement for account to be taken of the state of complaints when promotion decisions are aware. Now, the Court of Appeal recognised the importance of this because it was aware, as we understand it, that the officer concerned, Superintendent Hewitt, had in fact resigned by the time of the Court of Appeal's judgment. So the Court of Appeal didn't regard it as academic, and certainly we would say...
Did he resign or did he retire?
I think he actually resigned as a sort of form of early retirement. I think it was that's what I understand, I think. The other point that we'd make is that the fact Indicom was said to be nascent at the material time in our submission is also irrelevant for a couple of reasons. Firstly, there's no evidence to suggest that's the case. But secondly, and more importantly, whatever was happening in practice cannot change the legal position. And by the time in question, it's quite clear that the statute had established Indicom as an independent investigator, and it had the necessary powers and duties. So just in terms of the 2 documents that have just been handed up, now the court has them, or the committee has them. The key one is the one that is headed 2017, the year in review, because that's the one which is a sort of annual update, and page 41 is where the criticisms, page 41 onwards, where the criticism is of the lack of progress with Indicom. The other document is just really there for completeness because of our duty of candour, and it is the more recent quarterly review. It says, I have to accept nothing about the Police Service Commission. We assume that's because it's essentially not a sort of comprehensive review of progress that's been made during the year.
Mr. Southey, so far as the applicability of the new regime is concerned, my understanding is that that Indicom had been functioning for exactly 12 months before the recommendation for promotion was made. And it was the submission in the Court of Appeal that 11 of the 28 complaints would have been within the remit of Indicom. Is that right? Is that right?
I think that's right. Yes. That's as I understand it. Yes.
Thank you.
And indeed, in fact, if one looks at the complaint made by the appellant, several of them had in fact also been lodged with Indicom as well. So there were on the face of it, complaints that have been positively lodged by the appellant with Indicom.
Thank you.
Turning to the facts, I'm not going to spend much time on it, in part because what doesn't appear to be an issue, certainly isn't put in issue by the statement of case of the respondent, is that there had been an investigation into the conduct of Superintendent Hewitt that was sufficient to comply with standards of international human rights law, and obviously we would say the Charter as well. The issue primarily is obviously whether or not those standards applied to the Police Standards Commission. But despite that, there's 6 factual matters that I think that we would submit rather are important as part of the context and need to be taken into account. The first is that it's important to recognise that the superintendent was alleged to have been involved in a series of incidents, both incidents where he was the actual shooter, but more significantly perhaps, and certainly greater in number, a number where he was the team leader. And team leader cases in our submission are important. We'll come to the right to life later, but our submission is that the right to life requires operations to be organised in a manner that safeguards the right to life. And obviously that suggests it's particularly important that senior officers are acting in a way that's consistent with the right to life. And the number of cases in our submission is important. I won't take the court to it, but I'll give the reference to it. Unsurprisingly, the English Divisional Court in Musa, which is volume 6, tab 42, page 2936, made what, and it's paragraph 192, made perhaps what would be thought to be an uncontroversial point where they indicated that the case for a public investigation is stronger the greater the number of incidents. And that must be right in our submission because if there are a number of incidents, that calls into question suitability, essentially, of the officer and whether or not what's occurred is merely sort of an isolated incident. The second point that we would make about the facts is that it's clear on the papers that there were concerns about the conduct of Superintendent Hewitt. The letter dated 22nd of September 2009, which is in the record of proceedings at page 32 from the Police Service Commission, indicates that the Commissioner of Police had counselled and warned Superintendent Hewitt. More significantly, probably, at page 100 of the electronic bundle, which is in the record of proceedings, one sees the letter from Mr. Gores, who was the Assistant Commissioner of Police in charge of the Bureau of Special Investigation, which indicated that some of the shootings were said to have been questionable, and the allegations against Superintendent Hewitt were serious and needed to be investigated. And of course, one has the remarks of the Special Rapporteur, which are in the electronic bundle at page 46, where the Special Rapporteur specifically criticises Superintendent Hewitt for his aggressive and threatening manner. The third point we'd make about the facts is that it cannot be said in our submission that these concerns were raised at the last minute. The state, in its various forms, had been aware of criticisms of the superintendent for a considerable period of time. The appellant had complained in September 2009, it's electronic bundle page 34, that the response to complaints about Superintendent Hewitt was inadequate. And of course, again, I suspect there's no need to cite these authorities. Under international law and any human rights law in any event, the state is obliged to act of its own motion when there are killings by state agents. I'll come to that in a moment, but I suspect the committee is well aware of that authority. And of course, the state is obliged to act promptly. And yet, on the face of it, there'd been a number of allegations floating around for a considerable period of time which hadn't really been investigated. The fourth point we'd make is that the information before the Police Service Commission in our submission was limited. And in particular, there was no real attempt to obtain independent material about the performance and record of the officer. If one looks at the affidavit of Mr. Shirley of the Police Service Commission, page 78 of the electronic bundle, again the record of proceedings, one sees at paragraph 30 how, when the first decision was taken that further information was required, that was sought from the Bureau of Special Investigations, in other words, part of the police. A similar decision was taken in January 2011. So the first port of call, indeed the only real port of call, appears to have been the police in terms of information about the performance of Superintendent Hewitt. Now, there was, I accept, an interview with Superintendent Hewitt, but it was only with Superintendent Hewitt. And, of course, we would say that is problematic for several reasons. Firstly, if one's going to interview people, and interviews are important, it's important that everybody's interviewed, because interviews, including witnesses, because interviews in our submission are important, as the European Court has recognised. I'll give the committee the reference. It's volume 5, tab 34, page 2571, Maximoff. Interviews are how one assesses demeanour. And so if one has witnesses, as there were, to these incidents, one needs to speak to a number of them to assess their demeanour. But secondly, and probably more importantly in some senses, if one looks at the record of the interview, and there are a number of records, as I understand it, completed by each of the interviewers, starting at page 126 of the electronic bundle. What happens is that the interviewers are asked essentially to score Mr. Hewitt, as presumably they were other candidates, against a number of criteria. Not an uncommon procedure, one might think, but the criteria that he was marked against didn't essentially include disciplinary issues. And so we would submit the evidence of the appellant, essentially, which is that the interviews, in their view, didn't involve Superintendent Hewitt being asked about his role in each of the incidents, is correct. So the interviews don't really fill the gap. The interview, rather, didn't really fill the gap. It wasn't an attempt to find out what happened during the incident. So the only real source of information about the incidents was the police, and they obviously lacked independence. The fifth point that we would make about the facts is that it's also clear that at the time the decision in question was taken, there were a number of investigations outstanding. To use an example, there are a number of summaries, essentially, of the state of the various allegations. One example, an early example from January 2011, is at page 142. And one sees their electronic bundle, page 141 and 142, and one sees there a number of incidents that are said to involve Superintendent Hewitt, summarised, where it's clear that investigation still continued. Now, one aspect of that is that certainly at an early stage in the information gathering, it was apparent that statements from Superintendent Hewitt had been outstanding for a considerable period of time. Now, it does appear those were supplied, but it is of some significance that some of the hold-up does appear to have been caused by Superintendent Hewitt. Now, what is also important when looking at that point I've just made about the fact that investigations were outstanding is two things. Firstly, I won't take the court back to it, but we'll remember the letter from Assistant Commissioner Gores of the Bureau of Special Investigations. He had said, in terms, there was a need for thorough investigation and action. No indication that that was followed up. Secondly, page 59, one sees the record of complaints made by the appellant. Unsurprisingly, the three most recent complaints made by the appellant had been directed at Indicom. It's page 59. That's what I was referring to when I think in answer to a question by my Lord Lloyd Jones. So there were apparently complaints to Indicom, but there was no attempt on the papers, it would appear, to follow up those complaints and see what had happened. And so, as I say, the overall picture one gets is that there were investigations outstanding in relation to Superintendent Hewitt. Some of those, it would appear, were being potentially conducted by Indicom. But on the face of it, there was no attempt to gather the conclusions of those investigations and take account of them as part of the decision-making. Finally, it's important to note that despite the limitations I've already highlighted in terms of the investigations and the state of them, the conclusion reached, and this is important when one looks at the common law arguments, the conclusion reached essentially, and one sees it at page 532, is that the Police Service Commission was of the opinion it had sufficient information to take a decision, and one sees that, as I say, record of proceedings, page 532, a letter from the chair of the Police Service Commission dated 29th of March 2011. So that's really all we wish to say about the facts. That's our summary of the key aspects of the facts.
Mr. Sully, can I just ask,
Yes.
because in a sense the position changed with the note coming in, what the appellants really seek to get from this hearing and the decision of the committee?
Well, the critical thing from the appellant's point of view is obviously that the Court of Appeal judgment is set aside, because the Court of Appeal concluded essentially that the Police Service Commission has no role, essentially, in assessing complaints of this nature before deciding whether or not to make a promotion. Now, obviously, as a matter of practice, we're now told those sorts of decisions are taken into account, although, as I say, there is an issue about the extent to which factually that is happening on the ground. But the critical point is that even if that is happening, it is apparently not as a matter of law, it's a matter of practice. And that could change tomorrow. And in our submission, in the context, particularly of a state like Jamaica, where there has been a history, an unfortunate history of alleged extrajudicial killings by police, it's important that it's established that the Charter, in particular, applies in this context and imposes obligations on the Commission to ensure that it's fully informed about the disciplinary records of people it's promoting.
So where the note says should do that degree of investigating and take the matter into account, you would like it to be said must?
Yes, yes, because that should, as we understand it, given what was said by the Court of Appeal, must at the moment simply be a matter of practice.
And the investigation, it is said in the note, could be by seeking a report from Indicom, and you don't complain about that?
Absolutely not. In fact, we would accept that Indicom are likely to be the better organisation to carry out those investigations, because they are clearly set up to carry out independent investigations.
And it does look as if there is a concession, as far as I can see, the regulations referred to in paragraph 12 of the note are the same as they were at the time of these events, that there was power then to seek a report.
That seems to be certainly what is said, as we understand it, in paragraph 12 of the note. That's slightly inconsistent, we would say, with some of the things that are said in the statement of case by the respondent.
That was why I was raising it now, to
Yeah.
see whether, in fact, there's less debate than might have been.
Well, I certainly from our point of view, if it is accepted that those regulations effectively give the Commission the power to seek that information, that goes some way to really.
So your case is, faced with this sort of situation, the PSC should seek a report from Indicom, take into account the contents of that report in making their decision?
Yes.
Must, not
Must.
should.
Yes, must.
Well, I have a rather more prosaic inquiry. You referred us to page 532. It doesn't seem to be of any significance in the case.
Sorry, I think I may have got confused in making my notes between the two.
Well, never mind.
I'll come back to you.
Come back to it, yes, come back to it.
Yes, yes. Yes, I'll come back to you on that, sorry.
It's all right.
Can I turn then to the Charter? The Charter in our submission is the starting point, because it plainly is the governing human rights provision in Jamaica. The Charter is at core volume 1, tab 1, page 620. And its aim, in the preamble to the legislation that enacted it, was said to be to provide a more comprehensive and effective protection for fundamental rights. And in our submission, that's important. By the use of the word more in our submission, it is quite clear that this is intended to be interpreted in a way that is effective and should be interpreted broadly, not narrowly. That, in our submission, is consistent with the decision of the Jamaican Supreme Court in Gerville-Williams, and in particular the judgment of Mrs. Justice Lawrence Beswick, which is at volume 1, tab 7, page 821, paragraph 72, who indicated that essentially the paragraph 72, that the previous rights had been regarded as inadequate. Turning back to the Charter, at page 621, tab 1, starts in section 13(1)(a) with a statement that the state has an obligation to promote universal respect for an observance of human rights. Consistent with that, it said that the provisions that follow, one sees that over the page at 622, top of the page, so the provisions that follow are for the purpose of affording protection. And in our submission that's important because when one then comes to the rights, one sees at section 13(3)(a), the right to life. The right to life in our submission needs to be read in light of what precedes it. And the reason why, in other contexts, the right to life has been held as incorporating essentially procedural rights is because without procedural rights, the substantive right is less effective. And so, in our submission, when one looks at the substantive rights set out in section 13(3)(a), one needs to take account, as I say, of the need to promote observance. And how does one promote observance? It's by, in our submission, ensuring that there is an investigative, investigative steps are taken, because the investigative steps are what provide effective protection.
Well, this is all very well trodden territory.
It is. It is. I mean, this is not. The reason I'm going through it is that, as I understand it, my learned friend's argument in her statement of case distinguishes between what she describes as a positive obligation, which, as I read it, is an obligation essentially to carry out an investigative obligation, and a negative obligation, an obligation not to take life. And what my learned friend says is that the Jamaican Charter is only concerned essentially with an obligation not to take life. Now,
well, what I was going to say is that well-trodden territory in Strasbourg jurisprudence, do you say that that should be analogized into Jamaican law?
Yes, essentially, but I wouldn't put it quite that way, in the sense that what we would say is it's not just Strasbourg. Strasbourg perhaps is the most developed case law, but it's also, for example, been recognised by the Inter-American Commission when interpreting the American Declaration, the American Convention rather, and that's important because that is something that Jamaica has signed up for. And so what one sees is a recognition that this is a general standard that is derived from essentially provisions of international law that are the same universally, because obviously the International Covenant also uses the same language.
Well, I suppose what you might say is that what Strasbourg has illuminated is that to be practical and effective, the right guarantee under Article 2 requires that there be a backup, so to speak, by proper investigation. Now, that is a proposition can be made independently of any interpretation of European law. I mean, that's you would say, I assume, a universal
exactly.
proposition.
Exactly. I mean, and it's not. I should perhaps clarify the answer I gave a moment ago to my lord, which is we're not saying effectively Strasbourg applies in Jamaica, because it plainly doesn't. What we are saying is that, as my lord said, Strasbourg illuminates what is meant by the right to life, which is a universal standard, and one that Jamaica has clearly recognised in the terms of the Charter.
Mr. Southey, in this case, there's in his judgment, Justice of Appeal Morrison, at paragraph 90, finds that there is an obligation to have some form of independent and effective investigation. I don't understand that to be disputed.
Well, The difficulty I have, which is why I've gone to this, and I agree, and in fact, the answer I should have given to my Lord Kerr should have pointed to the fact that not only did the Court of Appeal appear to accept that there was a right to an effective investigation, the Supreme Court in the Gerville-Williams case has also made that point as well. The reason I went to it is that my learned friend in her statement of case spends a lot of time saying there is no positive obligation imposed by the Charter. Now, I accept that doesn't say in terms there's no obligation to investigate, but if the implication we took from that was that was being said, that there's no obligation to investigate, because otherwise we didn't really see why it was being said there was no positive obligation. And that's why I'm sort of spending a little time on this, because, as I say, that's how we understood what was being said in the statement of case.
Well, we'll be told in due course, no doubt.
Yes.
But are we concerned with any other positive obligation other than the obligation to investigate?
Well, what we also identify, and we would say, is that one of the underlying purposes of the Charter, and we refer to a recent judgment of the Caribbean Court of Justice in the Nervais case in relation to this, the underlying purpose of the Charter is to ensure that decisions aren't taken in an arbitrary manner, effectively. And we would submit that when looking at the particular issue that arose here, which is whether or not there was a need for information about the nature of the complaints and how they'd been dealt with, that underlying objective is important, because if one isn't going to take arbitrary decisions, one has to be fully informed, essentially, and taking decisions without this runs a risk of them being arbitrary.
Could you give us the...
It's a duty to inform yourself.
Yes.
Yes. Thank you.
Could you give us the reference to the Caribbean Court of Justice?
Yes, it's the judgment in Nervais. Sorry, I'm just looking for the precise reference. It's in the core volume of authorities at tab 8. And the relevant passage is paragraph 45. It's page 958. Thank you. So, I'm quite happy to, given the indications from my Lord Kerr and Lord Lloyd-Jones, to sort of go through to move on to some extent and save this for reply.
I was going to say, I think you've made your proposition, and and it's probably better, for my part anyway, that you deal with it in reply.
Yes.
In paragraph 4 of the note, it said that once there is a police shooting, as a matter of course, Indicom investigates as it is required to do by the 2010 Act. But I've been looking at the 2010 Act. We're missing bits of it from the bundle. I can't find that obligation precisely.
Well, I think actually it is in the material that we've got. I can give...
But if that's right, then doesn't it go around the... by another route to the same places you want to get?
Well, except, and this is of importance, and this links in to some extent with the factual material that we handed up this morning. Obviously, it's important that Indicom carry out investigations, but here the key decision, which is the promotion decision, is taken by the Police Service Commission. Now, the real issue in the Court of Appeal's mind was whether the Police Service Commission are essentially obliged to either find out for themselves or find out through Indicom what is happening with disciplinary matters. And the conclusion of the Court of Appeal was that effectively the Police Service Commission could act, we would say, in a vacuum. I hope that's not an unfair summary, but that's certainly what we would say the conclusion of the Court of Appeal was. And that's the problem, and that's still, on the Indicom report, still continues to be a problem, because the what Indicom are criticising in the report we handed up, essentially, is the Police Service Commission getting information from Indicom and then doing nothing with it, essentially. And so that's why it in our submission, is important to recognise that it's not just Indicom that has an obligation to act, it is the Police Service Commission that has an obligation to act.
So where do we find the duty to inform oneself?
Sorry?
Where do we find the duty on a public body to inform itself? Because paragraph 45 of Nerves doesn't actually refer to that.
Paragraph 45, sorry, I'm going to, can I bring it up, bring it back?
It's page 958.
Sorry, what I may have sort of slightly, what I
That,
was
of course,
trying to
is a
say-
case from Barbados. It's not a case from Jamaica.
No, but it's a very, the provisions are very similar. The critical point that's made in paragraph 45, essentially, is that there is a protection against arbitrary exercise of powers. Now, the point I was making was that if you're not properly informed, so you don't have the information necessary to take a decision, then there is an inherent risk of the decision being an arbitrary decision. To use there's a Trinidad case, Thomas, that talks about why bodies like the Police Service Commission are set up, and it makes the point that the reason why the Police Service Commission was established, essentially, is to ensure that objective decisions are taken rather than decisions influenced by political considerations, for example.
I suppose you might say,
Now,
operating from first principles, if you're an appointing body, you want to discover everything about the candidate that might sound on the suitability of his appointment.
exactly, and if one doesn't do that, if one sort of just goes in and is only partially informed, the less information one has, the greater the risk that one's taking an arbitrary decision. So, my Lord, going back to my Lord's question about Nerves, I was starting from the point that the Constitution guards against arbitrary decisions, and saying the implication of that has to be that you're fully informed.
It may be that you don't need authority, as my Lord says, that you don't need authority for the proposition that a public body should inform itself.
Well, obviously there's the general common law, the general public law duty, and we make reference to that elsewhere. All I was trying to do with Nerves was saying that in a particular in the particular context of a judgment that potentially bears upon constitutional rights, it becomes particularly important that you are fully informed, because if you're not fully informed, you risk breaching the Charter by taking an arbitrary decision.
Thank you.
Given, I think, as I say, the indications I've just had about the right to life, I'm going to probably save what I was going to say for reply, and we'll see what is said and whether or not it's accepted, effectively, that the right to life includes within it procedural obligation, which is, of course, is what the Court of Appeal found, as I think one of the committee has pointed out to me. What I would say, though, beyond that, because this, in one sense, is relevant to the role of PSC, is that obligation, if one accepts that there is an obligation under the Charter which reflects the sort of obligation that's been identified by the European Court of Human Rights and has been identified by the Inter-American Commission, then in our submission that has to have implications for promotion decisions. And we draw attention in particular to two authorities of the European Court and one of the Inter-American Commission in relation to that. If one looks at the Duran judgment, which is at volume 1, tab 5, page 738, paragraph 64, one sees there, clear statement from the European Court, that there is a need to suspend an officer during an investigation.
That's not what it says. Well, it says where a state agent has been charged with crimes involving torture or ill treatment. It does then refer to the investigation, but is that limited to cases where which result in a charge or not?
Well, two things I'd say about that. Firstly, of course, the European Court uses charge in a particular way. Charge is not what we would necessarily regard as a charge domestically. Charge is essentially giving someone notification that they are at risk, I think, paraphrasing, but I hope not inappropriately paraphrasing. But secondly, and probably equally importantly in our submission, one needs to look at what the origin of paragraph 64 is. And in our submission, paragraph 64, the paragraph 64 has its origin essentially in the sorts of concerns that one sees expressed in paragraph 60, which are that without an effective investigation, there is a risk of impunity, and there is also a risk that public confidence will be undermined. And in our submission, if you have a situation, and this is a sort of classic example of that, we would say, where one has an officer where there are real concerns being expressed, for understandable reasons, to effectively ignore those considerations runs the risk of undermining those two objectives, runs the risk of sending out a message essentially that the authorities aren't terribly interested in the allegations, and runs the risk essentially of sending out a message that there is a risk runs the risk rather of sending out a message that undermines public confidence. And so, my lady, going back to my lady's question, in our submission we would say the real touchstone in this context, when looking at whether or not there's a need for suspension, is will essentially public confidence be undermined if there isn't a suspension, and will it send out a message essentially that the authorities are not taking the matter sufficiently serious?
Well, depending on the nature of the charge, I think there might be a rather more fundamental reason. I mean, if someone is accused of using his position to bring about the death of an individual, an investigating body surely would turn its mind fairly rapidly to the question of suspending that individual, because for the rather prosaic reason, if it proved to be the case that that person had committed the offence, one wouldn't want to have to explain why he had not been suspended in the meantime.
Well, yes. And in fact, in our statement of case, we identify a third reason as well, which is that, of course, there are obligations on the state to ensure that operations are properly planned and properly organised. And if you've got someone who is under suspicion, sending them out to carry out further operations may be the state effectively sending out someone who is unsuitable. And
I mean, I think it probably does depend on the nature of the charge, because not every trivial allegation should lead to suspension. But
well, Duran, I mean, going back to the actual language, Duran talks about charges involving torture or ill treatment.
Yes,
I mean, because obviously it's an Article 3.
That's what my lady pointed out.
Yeah, case. So I would accept, obviously, if the charge is, I don't know, a disciplinary charge, for example, not filling in a notebook correctly or something along those lines, that would be a different matter. But, I mean, what I would accept to some extent is that what this is indicating is obviously there has to be a degree of substance to the allegations. The problem here, when one looks at what happened in this case, is of course because the information wasn't really sought out, there's no real information that allowed the Police Service Commission to assess whether or not these did pose the sorts of problems that we would submit are identified in Duran.
But is this not essentially incidental to your main case? I mean, the question of whether he should be suspended or not doesn't seem to...
Well, the reason we draw attention to that is that that authority then links in with GAFGAM, which makes a similar point about promotion. I mean, if sort of in one sense, promotion is the complete opposite of suspending someone.
Yeah.
It goes even further in the sense it's saying we're sufficiently we're insufficiently concerned to prevent you actually progressing up the tree, so as to speak, rather than. And GAFGAN makes that point. It follows. If one goes, it's the next tab. It's tab 6, page 776, paragraph 125, where based on this principle that officers shouldn't be charged, officers should be suspended rather, it is then critical essentially of the German authorities for promoting someone who was subject to investigation, promoting him to Chief of Police. So, my Lord, that's going back to my Lord's point as to whether or not it's relevant. That's why I've drawn attention to it to some extent, because one sees the European Court linking the two issues, promotion and suspension.
Well, I suppose the thing is that the underlying philosophy is that you should hold your hand on the question of allowing someone to continue to operate as a police officer, and likewise you should hold your hand on whether or not to promote that individual until the result of the investigation is known.
Absolutely, and for the reasons both my Lord gave and I've identified, for all those reasons, there are good reason to do that. And that isn't necessarily going to cause, if a state is complying with its obligations to investigate promptly, it wouldn't necessarily cause a huge amount of delay, because one would expect prompt action. And part of the problem in this case is that investigations were pending for a very long time.
I think it's very useful to refer us to GAFGAN because that's a Grand Chamber decision.
Yes.
And frankly, it's the Grand Chamber decisions we're interested in.
Yes.
Not stray chamber ones.
Yes. No,
what material do you rely upon to lead us to the conclusion that where in both these citations there's a reference to after charge, it's not referring to some process which leads to some prosecuting authority thinking there's a case to answer?
In our statement of case, and I haven't got the authority to hand, Strasbourg has been fairly consistent in making it clear that charge is that charge is not the domestic charge, effectively. The language at Strasbourg uses the word charge to imply essentially notification. Can I come back? But
yes,
it's basically notification of the fact that there is some formality to the investigation. So, to use an example, charge has been held to apply to people who've been interviewed.
Well, we've got to look at all of this in the context of civilian processes, haven't we?
Absolutely. But also, one has to look at it in the context of one other point, which is, of course, these provisions have to be interpreted effectively. And if the state is taking no action, the state can't, in our submission, justify a failure to suspend on the basis, well, we've not carried out our own obligations to carry out an investigation. I mean, here one's in the position where part of the problem we would submit is that there were a large number of allegations which just weren't being investigated on the material before the Police Service Commission. That can't put the state, in one sense, in a better position. Turning a blind eye to material can't justify inaction in circumstances where, if in fact there'd been a prompt investigation, material would have been turned up. Could I just also, in passing, note, because it is, I think it's important to recognise that although Strasbourg perhaps has said more about this topic than the Inter-American Commission, the Inter-American Commission does appear to have expressed similar concerns. If one looks at the Wallace de Almeida decision, which is in the same core bundle, tab 10, paragraph 59, sorry, 1015,
Sorry,
paragraph 59.
59, thank you.
Paragraph 59, it records the Commission essentially appearing to be critical of the fact that bonuses were effectively paid to police officers who were suspected, who'd killed those suspected of committing crimes, and that there'd also been promotion of police who were alleged or accused rather of victimising criminals. And that seems to be the context in which at paragraph 60 the Commission is critical essentially of a lack of respect for international human rights standards. So as I say, we would certainly argue it is not, the concerns expressed by the European Court are not restricted to the European Court, and that's for good reason. Because the fundamental point, as I say, is that, and this is also, going back to my Lord's question about charging, why one shouldn't get too wrapped up in our submission on whether or not there's a formal charge, one needs to look at what the underlying objectives are. And I go back to the point that the interchange or the exchange I had with Lord Kerr a moment ago. We would say the objectives are to ensure public confidence, to ensure that people are deterred from breaching standards, and to ensure that people who are appropriately qualified are carrying out risky operations. And that's where one looks at whether or not the state is taking an appropriate promotion decision. That's how one judges whether the state is taking an appropriate promotion decision. So we do submit, as I say, that to the extent there is a procedural obligation inherent in the right to life, in our submission, the procedural obligation includes an obligation to ensure that when promotion decisions are taken, proper account is taken of the state of disciplinary proceedings and whether or not someone is suitable for promotion in light of those disciplinary proceedings. Can I then go to what may be the central issue really, given the approach of the Court of Appeal, which is whether or not that obligation applies to the Police Service Commission. The Police Service Commission is established by the Constitution, and one sees that in Volume 1, Tab 2, page 694, section 129. Now, the section 129 is of some relevance because quite clearly what section 129 is intended to do is ensure that the Commission is independent. And one sees that, examples of how that's achieved in subsection 3, which limits the offices a member of the Commission can hold. One sees that in subsection 4.
Could you just remind me of the page reference?
Sorry,
please?
page 695, sorry.
Thank you. If one doesn't get it down straight away, it's gone.
Especially when there are tab numbers and paragraph numbers.
Yes,
And
so
Yes, no,
I'm so sorry.
No, I'm very conscious of the fact I quite often forget the page number as well.
You do, Mr. Southey, you do. Right, what they are not allowed to do.
Yeah. Section 3 limits the public offices they can hold. Section 4 limits their ability to take posts, essentially, that are subject to appointment by the Commission. And subsection 7 protects their salaries. All of those are provisions in our submission that are intended to ensure independence. Now, the particular role that they play in promotion and discipline is clear from Section 130 read with Section 125. Section 125 is a provision that governs another body which essentially operates in parallel, which is the Public Service Commission. And Section 130 applies Section 125 to the Police Service Commission with appropriate changes. Now, Section 125 is important for a couple of reasons. Firstly, not only does it make it clear that the Commission is responsible for appointment decisions and promotion decisions by implication, it also makes it clear that it's responsible for discipline. So in our submission, one sees from the Constitution itself a recognition that there is a relationship, unsurprisingly, we would say, between promotion and discipline.
Which subsection in Section 125?
So it's subsection 1, essentially. Which
Exercise disciplinary control.
Yes, exactly. The second point we'd make about Section 125, unsurprisingly, is it makes it clear that the exercise of the power in Section 125 is subject to the provisions of the Constitution. So, unsurprisingly, it's subject to the Charter. Now, the purpose of the Commission was identified in the context of a Trinidad case. It's touched on it already, Thomas, by this committee, which is at tab 9. And it's electronic page 994. And one sees by letter C that the idea of the Public Service Commission, the purpose of the Public Service Commission, and we would say by implication the Police Service Commission, is to isolate members of the civil service, and we would say in particular the police.
Insulate.
Sorry?
Insulate, not rather.
Insulate. Sorry. Insulate members of the police from political influence. And they do that, obviously, by the establishment of an autonomous commission, and that's why one sees the provisions I've already drawn attention to, which are clearly intended to ensure independence. Now, the implication of that one sees, or the key implication of that one sees identified at page 996 by letter H. And that is that decisions have to be taken for good cause or reasonable cause. Decisions can't be taken on a whim. And that's important in our submission because that's the context in which we submit the rules that follow should be considered, because in our submission, goes back to the point I made a moment ago, really, that in our submission, if decisions are going to be taken for good cause, the implication of that has to be that there is full information before the Commission to ensure that properly informed decisions are taken. links back to the point I made earlier about how the Constitution requires decisions to be taken in a manner that avoids arbitrariness. Now that is the context of the police service regulations. They are at tab 4, page 720. Memory stick, page 720. Regulation 9, unsurprisingly given what we've just said, just given what I've just drawn attention to, rather, makes it clear that there is a wide power to consult. And then in the particular context of promotion decisions, going over 2 pages, Regulation 15.2k allows for special reports to be called for. And obviously the note accepts now that those provisions are the provisions that allow for information to be obtained from Indicom. And that's not surprising given Regulation 15.1 expressly says that when taking promotion decisions, one has to take account of merit, ability, and good conduct. Obviously, it would be surprising if those factors weren't relevant, given what I've already indicated, which is the whole purpose of the Police Service Commission is to ensure that decisions are taken in a manner that is not arbitrary. Now, the statement of case, essentially, argues, rather the respondent's statement of case, argues several things. It argues, firstly, essentially, that there is no power or duty to investigate. We would submit that, firstly, the powers of the Commission need to be read in light of the Charter, and if the Charter imposes duties to investigate, then the Commission has to comply with those. But secondly, more importantly, in any event, there is no need for an investigation to be conducted by the Commission in person. The powers that I've just drawn attention to quite clearly allow the Commission to obtain information from Indicom. The second thing the statement of case on behalf of the respondent argues is essentially all that was required was a report from the police commissioner. And that was said to be a report under Rule 32.1. To put that in context, if one goes to page 724 of the electronic bundle, one sees, I've just drawn attention to the provisions dealing with promotion, but one sees there provisions dealing with discipline. In our submission, unsurprisingly, given that the Constitution vests disciplinary functions with the Police Service Commission, the rules anticipate the Commission continuing to take a role in relation to discipline. And so one sees in particular, looking at senior officers such as the officer in question, Rule 31.2, making it clear that it is ultimately for the Commission to decide whether disciplinary proceedings should be brought. Admittedly, that is after advice is obtained, but it's not in our submission the case that in relation to discipline, all that's required essentially is a report to be made to the Commissioner. What is quite under Rule 32.1, what is quite clear that in relation to senior officers, there is an expectation that the Commission will continue to have responsibility for discipline, and that is, in our submission, consistent with the Constitution. So in our submission, when one looks at the role of the Police Service Commission, firstly, it had an express duty to look at conduct when deciding whether or not to promote. And that's entirely consistent with the fact that it continues, or it has at all stages a key role in relation to discipline. Now, we would accept that in practice, it makes sense generally, it's likely to be the case, that investigations are carried out by Indicom. Indicom was established by the Independent Commission of Investigations Act. That is at tab 3. The background to it, though, before turning to that, is probably best explained by the Supreme Court of Jamaica, I should say, in Gerville-Williams, which is at tab 7. Page 833 is where the relevant passage starts. 833, paragraph 115. Mrs. Justice Lawrence Beswick sets out essentially how Indicom was established because there was a perceived need for independent investigations and because the public had no confidence in, to use the language of of the learned judge, Caesar investigating Caesar, and there was a concern that extrajudicial killings would continue. Similarly, one sees Mr. Justice Sykes, as he then was, paragraph 130, being critical, or recognising rather, not being critical, but recognising the fact that there was a long-standing problem with police killings. And paragraph 131, that had been criticised by a number of human rights groups. Mr. Justice Frank Williams, I'm not going to take the court to it, paragraph 366 makes similar concerns, or makes similar comments. So it's clear in our submission that the 2010 Act was intended to ensure that there was an effective response to extrajudicial killing and the concerns that have been expressed in relation to that. Now, in our submission, the Indicom rather has the powers it needs effectively to carry out those investigations, but it does that essentially by carrying out the investigations and then providing the information to the Commission, the Police Service Commission. The way it operates is set out in the Act, and if one goes back to electronic page 708, tab 3, one sees section 10 allows anyone to make a complaint, apparently, in the case of a death, among other things. Section 11 requires the head of police to report death cases, among other cases. And section 13 allows the Commission itself to carry out investigations of its own initiative. What then follows is that there are provisions for essentially informal resolutions. One sees those in sections 15 and 16. But if those mechanisms aren't used, section 17 requires an investigation to be made forthwith. And ultimately, one sees this at subsection 10. The Commission is required to submit complaints to a number of bodies, including the Police Service Commission.
For subsection 10 of which section? Section
17, it's page 714. So one sees a system which is essentially set up to allow Indicom to carry out the independent investigations which are recognised as being necessary in Jamaica, but Indicom then reporting to a number of bodies, including the Police Service Commission. Unsurprising in our submission that that is the case, given what we've already seen about the Constitution, which is that the Constitution makes it clear that the Police Service Commission is responsible for discipline. So going back to what that implies about this case, in our submission, if one is going to be properly informed about whether someone is suitable, and in particular whether or not their disciplinary record makes them suitable or not for a promotion, the obvious way of doing that is to have contact with Indicom. The way in which the regime seems to operate in our submission is that the Commission is responsible for discipline, the Commission is responsible for promotion, but Indicom is responsible for investigation. And that's the way, in our submission, going back to effectively the approach of the Court of Appeal, that's the way in which the Court of Appeal was wrong. The Court of Appeal essentially was of the opinion that the Commission had no real role to play in this, but the Commission does have a role to play in it because the Commission has to be fully informed, and it does, and it can do that by being in contact with Indicom. And they have to work as a partnership. And that, if one goes back to, I can see my Lady Hale looking at the report of Indicom. That's the more recent one, but that's not the one that includes the criticisms. Indicom's basic complaint in the report that includes the criticisms essentially is that the Commission isn't working with it. The Commission isn't following up.
The Commission can make recommendations as part of its report.
Yes.
And section 23 deals with compliance with recommendations.
Yes.
Is that a means it can use to ensure that the PSC does take account of what it said?
Well, I don't think that's been, I mean, as far as I'm aware, that hasn't effectively been tested. But the problem from what the PSC, according to Indicom in their report, the problem from the PSC's point of view has been, more recently, which obviously doesn't arrive on the facts of this case, that there is provision which talks about that there needing to be a report from the police commissioner, and the police commissioner just hasn't been submitting reports. And so the commission has taken the view it effectively can't conclude its work until it has reports from the police commissioner. That's what I understand the Indicom report to be critical of. So whether or not that is a legally appropriate way of dealing with it probably doesn't really arise on the facts of this case, but
that's not the PSC being problematic then?
Well, it's the PSC not taking action, it would say for good reason. Whether or not that, what I'm saying is I'm not necessarily conceding that is for good reason. But I would accept that doesn't really rise on the facts of this case.
What it comes down to really is this. I mean, your submission is that the PSC cannot adopt a position of passivity.
Yes.
In its role as a promoting or appointing body, it should tap any source of information that will be relevant to the decision that it takes. It knows that Indicom might well be a very fruitful source of information, so it's got to be active in soliciting information from that source.
Absolutely. Well, it can't comply with its own obligations unless it's fully informed.
Yeah.
And that's why, I've focused so far on the Charter, but we have very consciously not abandoned the domestic public law point, because you can make that point essentially independently of the Charter. The Constitution, in our submission, demonstrates it's important that these decisions are not arbitrary decisions, but decisions that are taken for good cause. If you're going to take a decision for good cause, that means you need to be fully informed, as the Constitution, we would say, also recognises, demonstrated by Nerves.
Well, you have to take into account those things that you ought to take into account and not take into account
Absolutely.
those things that you ought not to take into account. It's
Absolutely.
basically
Absolutely.
simple proposition of public law.
Absolutely. Well, except, I mean, the reason why I just talked about the Constitution, in the sense it comes back to the point that perhaps is floating around a lot in the Supreme Court and in this court at the moment, which is intensity of review. And when looking at whether or not it's effectively reasonable or not to fail to seek information from Indicom, the sorts of points we've made about the constitutional importance of being fully informed suggest a relatively intense review.
I think the Court of Appeal quoted Lord Justice Simon Brown in Smith, didn't they?
Yes. Yeah. Yes. But yes. So, and we're saying, I suppose, a different way of putting it is part of the context of looking at whether it's reasonable or not to fail to seek that information, is the constitutional importance of ensuring that this is a properly reasoned decision. That, I'm well ahead of time, probably covers everything I need to cover. Can I just double check with those who are behind me? And thank you. I think that covers everything. And, thank you.
Well, thank you very much, Mr. Southey. Mr. Dale? Madam Attorney.
I'll begin by indicating that the state takes seriously all allegations of breaches of human rights, and in particular, contravention of the right to life. There is no question that such allegations must be properly investigated and perpetrators brought to justice without delay. We take no issue. As S.B. Hewitt himself said, it is not an easy thing to kill someone. And this is found at page 145 of the bond when he was interviewed. As I understand the appellant's case to be here, is that the PSC did not take into account all it should have taken into account. Complaints against S.P. Hewitt were not properly and thoroughly investigated. So by the time they came to making their decision on promotion, they would not have been in place to make a proper decision. The argument was that the PNC itself had a duty to investigate, not that it should resort to reports from other bodies. If you look at how the claim was made in the fixed date claim form. Look at page 9, where the relief sought was that of mandamus to direct the PSC to conduct an effective, thorough, and impartial investigation. That was in the context of their saying that in light of what we have given you, credible and valid evidence contained in our letters, letter of July 29, 2009, then later in the letter of April 6, 2011, you should have investigated. So there is a shift in the arguments.
Shift had happened, though, by the time of the Court of Appeal, hadn't it? We could see the argument that they should have sought report from Indicom.
Milady, save and accept that when you look on how the arguments were made, there was much emphasis on whether duty existed and how the regulations ought to be interpreted to impose a duty, as opposed to seeing it as a discretion. So it was premised on the view that the PSC had a duty arising specifically under Regulations 9 and 15 to itself conduct an impartial, thorough, and independent investigation. We find clarity in how the appellant was challenging the decision of the PSC. And going back to the fixed date claim form.
Well, if the PSC had been made aware that there were 28 allegations of misconduct made in respect of an individual who was seeking promotion, and if there was no report available to the PSC in relation to the resolution of those investigations, was it not under an obligation to ensure that it was informed?
We take no issue with the contention that the PSC should take all steps to properly inform itself. But, my Lord, we have to look at the particular facts of the case, because we take issue with what is presented in terms of how the PSC handled the complaints. And it will be necessary for us to spend some time to look at the approach taken in the context of what was then available to it.
Just to return to the point, if you look at paragraph, say, 105 of the Court of Appeal's judgment, and paragraphs around it, there's an argument about whether the PSC were able to call for a report from Indicom, and the argument was being advanced that they couldn't. But in fact, on the note that you've put in, it's conceded that they could.
It's not that they couldn't. We were looking at the mechanisms that were then available. At the time, although the Independent Investigation of Commissions Act was passed, the Indicom was only 9 months in its operation. We see no particular reference to Indicom at the time, but there is no dispute that the PSC is given a discretion to call for reports. But once it calls for those reports, it is obliged to consider the reports.
Yes, but the argument, you can see it from those paragraphs around paragraph 105, was that they hadn't got the jurisdiction to call for a report from Indicom. That's what the Court of Appeal's addressing.
Well, the Court of Appeal is saying that they could not mandate anyone to investigate.
Okay. Well, if there was ever an argument about it, there isn't an argument now. The regulations, which I don't think have changed over the material period, do enable them to call for a report from Indicom.
There is no doubt about it, that, milady, but there was a slight difference. It was saying, the appellants were saying that you must investigate yourself. In the light of the allegations, you, the PSC, had a duty, specifically under the regulations, to investigate, separate and apart from the power that is granted to you to call for reports. So if we look at Regulations 9, it provides that the PSC may consult with such public bodies and other persons as the Commission considers proper and desirable, and may require any public officer to attend and give evidence before it produce any official documents. That is a discretion that is given, the discretion to consult. And for all of the arguments about how the Commission is established, given its autonomy, it is a discretion as opposed to a duty.
So when at paragraph 37 of your case, you say that the PSC has no statutory authority, either under the Constitution, the regulations, or the Independent Commission Act, to call for or request a report from Indicom, that's not right.
We're saying, based on how the regulations are worded, it gives them the discretion to call for those reports in the first instance, but once they choose to make the call, then they are obliged to consider. And it is what the regulations say. So
But
it's not,
if you're aware
we're not
that-
saying at all that they shouldn't have resort to Indicom.
Quite. But if you're aware that Indicom is in possession of reports that might influence the PSC's decision, does it not amount to more than a discretion? Are you not obliged to have recourse to that information?
My Lord, in the context of this specific mandate of Indicom, I would say yes. But at the time, different bodies existed and the discretion was given to consult across a wide range of public bodies. Now that Indicom is in place, it is the practice that matters are automatically referred to them. So the question was what existed at the time. And it also has to do with a proper exercise of discretion.
I just wonder whether it can really be confined to a matter of discretion. If you are an appointing body and you're being invited to appoint someone to a senior position in the police service, and you're aware, have been made aware, that there are many complaints against him, and if you're further aware that the various bodies may have investigated some or all of those complaints, are you not under a duty to make sure that you are properly informed by recourse to those bodies?
My Lord, I take no issue with that.
Right.
The PSC must put itself in a place where it is properly informed. And that is why it's going to be important for us to look at how it went about dealing with the numerous complaints and what mechanisms were then available to it in terms of addressing the complaints. The situation has changed slightly.
Right.
The situation has changed slightly, but we can take no issue with the fact that these are serious complaints. It is important that you get to the root of them in order to put yourself in a position to make a proper decision. We can take no issue.
And the submission was made before the Court of Appeal that 11 of the 28 complaints would have been within the remit of Indicom.
Well,
Was that right?
some of the matters, from the evidence, there wasn't really any reference. The system that existed at the time before Indicom was up and running, where there would be an automatic reference, and in fact, Indicom would go on the scene. There would be no need for a reference, because the way it operates now, there is a fatal shooting. It's on the scene, it investigates. It is empowered to take charge of the scene. That has created operational issues resulting in the need for protocol between the police and Indicom in terms of what happens in preserving the scene. The police are not devoid of their responsibility to also investigate, but it is where a police officer is implicated in a killing that Indicom has to go on the scene. So you have some of the matters that were referred. But if we were to look at how the Commission handled the matter, so complaints came to the PSC. The allegation in the letter of the first letter was that that letter contained credible and valid evidence. But if your lordships were to look at what was contained there and then, even the letter itself conceded that they were not in a position to substantiate the complaints at the time.
Which page is that?
At 27. And 28. The electronic one. So if we look at the first letter that was sent by the appellants to the respondent, starting at the second paragraph, over the past several years, JFJ has received approximately 13 complaints about unprofessional conduct of Mr. Hewitt. The complaints received involved allegations of 2 threats, 1 injury shooting, 10 fatal shootings committed by persons ostensibly under his direction and or in his presence. Some complainants in the fatal shooting matters have dubbed Superintendent Hewitt and his team the death squad. Then if you go over, it says, while we are not able to confirm the allegations, nor are we in a position to provide evidence to substantiate the complaints, the circumstantial indicators are disturbing enough that as a human rights organization, we feel compelled in the public interest to inform you of them. And if we just go back to the paragraph before, it appears that this said they had received it in their public consultation. It's not in this one. But at that stage, there were general allegations that were made. Not specific, but admittedly serious allegations. What did the PSC do, having received the allegations? The PSC communicated with the Commissioner of Police. And this is as it was supposed to do, according to Regulations 32. In fact, the PSC had a duty. Regulation 32 says, any report of misconduct on the part of a member shall be made to the Commissioner and be dealt with under this part as soon as possible. So the report is made to the PSC, and the PSC then brings it to the attention of the Commissioner of Police. And the Commissioner is obliged to conserve this. But so that was the starting point of the matter. So then the Commissioner responds by letter dated September 7, and that is found at page 90 of the electronic bundle. Commissioner points out that Mr. Hewitt is a very active police superintendent who leads from the front. In the last several years, he has been in command of two very tough policing divisions, St. Andrews South, and prior to that, Kingston West. Mr. Hewitt's style of personally leading his response team in a greater number of operations within his divisions places him at the locations of many police criminal confrontations. And for as many citizens who will condemn him, there are equal number who will commend him. It says Mr. Hewitt is well aware of the complaints and the nature of the complaints against him, and he's equally aware of his support base. Jenna says, I have taken great pains more than once to bring to Hewitt's attention the circumstantial indicators, to counsel and warn him accordingly. Any and every report of wrongdoing by Hewitt or any other member of the police force will be thoroughly investigated and action taken as appropriate. The letter was copied to Mr. Hewitt.
Well, it doesn't say whether any of the complaints have been investigated.
We're coming to that.
All right.
I understand. Because it's important.
I'll have to be patient.
The conduct of the PSC in dealing with the matter. So the PSC provides the appellant with a summary of the Commissioner's response in a letter of September 7th, and that is found at page 32. Appellant is informed that the matter was brought to the attention of the Commissioner of Police, as is their duty to so do, and that he has given the assurance that all reports of wrongdoing or against Hewitt or any other member of the force will be thoroughly investigated and that the appropriate action will be taken as deemed necessary.
Will you forgive me for saying that?
Indicom did not yet come into the picture.
That doesn't really add anything to the Commissioner's.
But Indicom, it's the response to JFJ being communicated by the PSC.
Yes. Right.
Really isn't anything new. But at this stage, Indicom had not come into the picture, my lord.
Right.
Yes. And then we have a second letter from the appellant on September 8th, and this is found at page 30. And they were seeking an update on the investigation, essentially. A third letter on September 29 at page 34, complaining about the inadequate response. Then, so they say it does not, having carefully reviewed the said response, we respectfully state that we find the same grossly inadequate, and it does not comprehensively address the grave allegations and concerns highlighted in ours. But we recall that that initial letter had not provided any details. So it would be for complainants to be located. It would be for those allegations to be investigated. There was nothing that could be referred to based on that first letter to say, here are specific allegations in respect of specific cases. And then the appellants went on to say, it may be that our misunderstanding emanates from a lack of sufficient understanding of the role of the Police Service Commission and its consequent powers. They were asking the PSC to do the investigation. They sought advice on the responsibility of the PSC in matters of this nature. Indicom not yet in the picture. Request was for you to investigate. You have come back. What you have said to us is clearly not enough. Is it that we misunderstand what your role is in the process?
At this stage, as I understand it, no question of promotion had come onto the scene.
No question of promotion.
So we read all this in the context, I suppose, of an assumption.
Right. So it's interesting. So the issue first arose in respect of complaint, and the regulation set out a procedure that you should go on. And then it was overtaken by a recommendation to promote SP Hewitt. And that is in the context of a number of things happening on the island at the time. So we have a fourth letter from the appellants on December 18 at page 38, referring to a telephone conversation with the chairman of the PSC. And it would appear that some assurances were given, because it says, we hope that the thorough investigation of the matter has now been undertaken, and respectfully ask that you provide us with the result of your findings. And the chairman of the commission had, in fact, promised by way of telephone conversation, that is found in his affidavit, to provide JFJ with a report from the Commissioner of Police. Page 72. Paragraph 13, page 72. I received a follow-up call from Dr. Carolyn Gomes in respect of the matter, during which a report was promised to the claimant after the receipt by the Commission of a report from the Commissioner of Police. Looking at the existing mechanism, Indicom not on the scene. Regulations say that any report of misconduct shall be made to the Commissioner and be dealt with under Part 4 of the regulations. Then we have January 13, 2010. Letter from the respondent to the appellant, and that is at page 40. of the record. I write with reference to our conversation and subsequent correspondence regarding the subject and caption. I have asked the acting commissioner, Mr. Owen Ellington, for his report, and he has informed me that the matter is receiving immediate attention. We would see that there was a change in the leadership of the JCF at the time. The first letter came from Commissioner Hartley Louis. Now we have acting commissioner Ellington. So we see that
Sorry, which paragraph is that, please?
40, my lord. Page 40. The letter from the PSC.
Oh, I see, sorry, page 40.
Right. So we see that the PSC is taking steps. It's not that it has received these allegations or the complaints and is doing nothing. The PSC understanding of its role is clearly different from the appellant's understanding at the time. So you complain to us, we are obliged to send the complaints over to the Commissioner of Police, and then we would do the follow-up to ensure that each and every allegation, each and every complaint is properly and seriously dealt with. So, not a case where the Commission is being passive and doing nothing about these complaints. So, the Commissioner asked for a report. Commissioner said the matter was receiving immediate attention, and the PSC would advise the appellants when the report is received. This is what is communicated to them. Then we go to January 18, where the Commissioner of Police sends the Bureau of Special Investigation a letter, and that is at page 99 of the bundle. So the commissioner, who still acting commissioner, in furtherance to my correspondence of December 16, 2009, relative to the complaint against Mr. Hewitt, please see attached report prepared by the BSI. And that was what was in place at the time. And this is investigation that was being done.
Would we have that report?
It's next
Yes,
page.
my lord.
Next page, is it?
100, yes.
Oh, right, yes, thank you.
But we bear in mind what the mandate of the BSI was. Indicom not yet on the scene. You can see, just to juxtapose the mandate of the BSI at page 180 of the bundle. Bureau was established, the mandate of investigating all cases of police shootings, fatal and otherwise. And in the discharge of the mandate, interim report is submitted to the Commissioner of Police within 24 hours after each incident over which the Bureau has remit, copies of which are submitted to the Director of Public Prosecutions, and then the Police Public Complaints Authority, and now they say the Indicom, but at that time.
The report of the BSI, which we have at page 100, does proceed at a very high level of generality, doesn't it? It doesn't even condescend to any detail in relation to any of the alleged incidents.
Right, but we're still at the early stages, my lord, yes. But at least the matter is, the process has commenced. So the PSC hasn't turned a blind eye. It is going through a process.
still no promotion question.
No
at this
question of
stage. What's the
promotion.
date for that, please? Just so that I can get it in the chronology.
The promotion came, my lady, at 1:04. So this is at November 25, 2010. So here, after the commissioner sends the letter from the Bureau of Special Investigation, we have a fifth letter from the appellants, and then we have a sixth letter, and then the commissioner writes to the PSC advising of 24 vacancies, and that's found at 104.
And what was the date of Indicom coming into force?
August 2010.
I have the date 25th of April 2010.
That's when the legislation
Was when the legislation was passed. Right, thank you very much.
So by the time the promotion question arose, Indicom was available?
Yes, my lady. And again, we take no issue with the very painful history that we have had in the jurisdiction of dealing with matters of investigations. And we've seen the response of the state over time to deal with these matters, to ensure that allegations are properly investigated, that they're taken seriously, and that the credibility of the institutions is developed in a way that would meet the demand. We take no issue. The country is plagued with a high crime rate. And a lot of the records show, the evidence reveal, that a lot of the incidents took place in special operations, military and police. And, you know, if the police go on the scene and they're fired upon, they will have to make a decision. Do they return fire? What do they do? It has been a sad reality of the level of criminality, and in particular, the evidence shows that SP Hewitt was placed in the toughest police divisions, where the criminals were not afraid to engage the law enforcement. And this is not to say that their rights are to be trampled on, but it is a harsh reality. And the evidence references a Tivoli incursion. Something was happening on the island at the time. There's no detail, and I do not wish to give evidence, but it is the harsh reality. So milady, if we look at where we are.
I'm sorry to take you back to the exchange of letters, but
Yes.
if you look again at page 40, that's
Page
a letter
40.
dated 40, yes.
Yes.
It's a letter dated the 13th of January 2010 from, I think it's Professor Shirley. And he says that I will inform you as soon as the report has been received. Now, you then took us to page 99,
Yes.
and that's a letter.
What is clear is that there was a lack of communication,
Yes.
up-to-date communication between the PSC.
Well, I'm sorry, I just want to be clear. Does the letter of the 18th of January 2010 at page 99, does that purport to be the report that was promised on the 10th of January?
The attached report speaks to, it appears so, but this report, no, it's a general report coming from Assistant Commissioner Gauze of the BSI.
Yes, I know where it's coming from.
Yes, but it's not specific in terms of each of the matters at this stage.
Yeah, well, quite, but the letter on page 40 promised a report.
Yes, my lord, the report had not been provided of the...
I see, so
Right,
that
yes.
there's still no report, right.
Not at that stage, yes.
No, right.
Not at that stage.
All right.
Right, and I think issues it appears that how much to disclose, how much details, given the sensitivity of the matters, may have played a part. I don't know. But what came in respect of the allegations of misconduct against Mr. Hewitt in the attached letter at 100. So there is acknowledgement of receipt of the correspondence, and they say, again, we see that Hewitt is operationally inclined. There's an expression of how unfortunate the complaints are and that they must be viewed against his style. He's operationally inclined. He has been involved in a number of operations in which illegal firearms have been recovered and notorious criminals arrested or killed in confrontations with the police. He's always willing to lead these treacherous operations, quality which is lacking among leaders in the force, so the report says.
Well, as my Lord has said, these are general comments. I mean, there's no indication of investigation, an actual investigation of the complaints having been carried out.
Not at this stage, my Lord, but if you were to look at pages 140, following 41 of the bundle, you would see the fatal shooting returns are set out there. But just to go back before, as part of the context, because context matters, and what the PSC had to consider on a totality of the evidence. And again, no disputing the need for the complaints to be properly and sufficiently investigated. No disputing that. But to put it in context, the Kingston Western and St. Andrew South divisions are two of the most volatile areas in the island. Crime statistics has revealed that St. Andrew South division in particular has been averaging over 200 murders for the past 10 years. These divisions require firm and decisive leadership, and that doesn't mean that the police are entitled to go in and disregard life. Doesn't mean that at all. He spoke to that his style of leadership in these hostile communities may reflect the concerns raised. Communities where the criminal is not afraid to engage the police, where there is no respect for law and order. This is context. But it says that the allegations they're serious and they must be thoroughly investigated and appropriate action taken. Commitment. And when you look at the end of the day, by the time the report came around, it was clear that investigations were being done. When you look at the status report, how many of the files were complete, sent to the DPP for a ruling, and it is a practice that where a police officer is implicated, before he or she is charged, the ruling of the DPP is sought. Incomplete files are not sent to the office of the DPP for rulings. Then you have matters being sent to the coroner's court, hearings have been done, verdicts returned. On the evidence, there were only 2 matters in which Superintendent Hewitt was the actual shooter. On those matters, the verdicts from the coroner's court were that justifiable homicide, and you can see that at page 141 of the record. So, my Lord, going back to your concern about whether each case was looked at. So we start at number 1. And if you see the report of the status, the file was completed and sent to the DPP, and they were awaiting the ruling. Insofar as the investigation was concerned, they had completed their role. Not an incomplete file. Number 2, again, the file was complete.
To interrupt, can you tell me the date on which this chart was prepared, the date on which the...
January 7, 2011, my Lord.
2011?
Yes. That is when the letter was sent.
I see.
And it was sent to the Police Service Commission?
Yes, it was sent to the PSC, yes.
Yes, I'm sorry, I interrupted you.
So, complaints received by the PSC, PSC sends to the Commissioner of Police, correspondence back and forth. We regard these matters as serious. We commit to investigate. It takes time. There are a number of complaints. Not a case of a blind eye being turned to these matters. Not a case of nothing being done.
The file on the first instance was sent to the DPP on the 3rd of October 2004.
At different stages, my lord. I mean, investigation is a process.
Well, I do appreciate that, but
And
I just want to be clear that I've interpreted this chart correctly. It was sent to the DPP on the 3rd of October 2004, and at the time of the dispatch of the letter, 7 years later, or almost 7 years later, the ruling was still awaited. Is that right?
my lord, it is really unfortunate, but that is what the evidence shows.
Yeah.
It is what it shows.
Whether it's unfortunate or not,
you
it
know,
has to be decided, but I just wanted to be sure that
Yes.
I got it right.
Yes. It says file completed and sent to the DPP 10th of the 3rd, 2004, and the ruling was awaited. But later on, we see that there was a meeting with the DPP's office to ascertain the status of all the matters that had been submitted to that office for ruling.
Can you just help me? We see that this document is sent by the Commissioner of Police under cover of the letter at 1:40. Do we know who within the police organisation conducted the investigatory activities of which this document is a summary? Is it the BSI or is it?
BSI is my understanding.
This is the BSI.
My understanding, yes. And the BSI had a specific mandate. Because even where there are investigations take place independently of the police still has a duty to investigate. Right. Senior Superintendent Gauze and his...
Because reading the report from the BSI, which is at, I think, page 100, isn't it? It rather looks as if they're saying, well, we quite agree all this needs to be seriously investigated, and there are various bodies that could do that if the public wants to make a complaint. It doesn't appear to be saying it is itself conducting any investigation at all. And yet this document appears to suggest that, in fact, it was and had been for some considerable time, and some papers have been sent to the DPP and others haven't.
A little differently. The BSI, the complaints span not just allegations of shooting, but other forms of misconduct. And in effect, what it was saying is that while the BSI dealt with the police shootings, the other bodies would deal with other aspects of the complaint. But, my lord, better light will be shed in looking at the affidavit of Granville Gauze at page 182. So he said he recalled I recall carrying out those investigations and reporting my findings to the then acting Commissioner of Police. So the investigations were carried out. And previously, in the preceding page, he said, I also recall former and then Commissioner of Police Lewin directing me to conduct an investigation into the allegations of misconduct made by the claimant against SP Hewitt as a result of requests made to the then Commissioner of Police by the defendant. And he was an Assistant Commissioner of Police at the time. So if we look at paragraph 5 on page 180, the SSP Gauze says, ACP Gauze, that I'm an Assistant Commissioner of Police in the Jamaica Constabulary Force with 41 years and 11-month service and presently in charge of the Bureau of Special Investigations and have been actively involved in investigations as a detective at all levels for the past 39 years, and that I have been in charge of the Bureau of Special Investigations since August 2003. He carried out the investigations. But just to go back to the report detailing case by case at page 141. In respect, listed at number 4, we see an incident where Mr. Hewitt's role was that of actual shooter. And that was a matter that was sent to the court. The verdict was justifiable homicide. You also see down at 8, where his role was actual shooter, and it was ruled justifiable homicide. When Mr. Hewitt was interviewed by the commission, he said in all of his years in the force, it was only 3 times he had ever used fatal force. And he said it really is not an easy thing to kill someone. That's at page 144. It says in his entire years. And he had been involved in many 11,000 operations. That's on page 145. End of 145, he added that it's not an easy thing to kill someone. But if we go back to 141, among the sets from the complaints about him, there were only 2 in which he was alleged to be the actual shooter. And those matters were fully investigated and dealt with and brought to finality. 8 says justifiable homicide. 4 says justifiable homicide. And in all of his many years, only 3 incidents. But apparently the 3rd one is not among the complaints against him. So I don't know. But we do know that he has been charged. So far be it from a case where the commission, having received the complaints, did nothing. The commission itself was not an investigative body. And so it could not have embarked on the kind of investigation that the appellant was insisting on. But even the appellant acknowledged that it may have been confused about the role of the PSC. And as the PSC had a duty to do, it referred the matter to the Commission of Police. And within the mechanism then available, investigations were done. Unfortunately, there wasn't communication in a timely way between the appellant and the respondent. And in the absence of that, there may have been assumptions and questions as to whether anything was being done.
Well, the responsibility of the Commission, at least part of the responsibility of the Commission, was to oversee disciplinary matters. Isn't that right? And here you have a list of complaints against Mr. Hewitt, some of which involved him actually carrying out the killing, but all of them, I think, involving him in a position of authority. And the delay in investigating those complaints is really quite remarkable in many of the cases. Surely the Commission had an obligation to say, well, look, we can't discharge our duty of supervising discipline correctly unless there are prompt investigations into these very, very serious allegations.
My Lord, any concern that you raise about delay is here. the sheer number of matters to be investigated, the available resources, whether witnesses are cooperating, particularly in communities where there is a certain attitude towards law enforcement, and if you have...
Well, I do understand all of that, but there's no correspondence emanating from the Commission saying, look, we need to have progress here, because how are we going to discharge our duty?
Well, the chairman from all indications, there was constant communication or timely communication between the PSC and the Commissioner of Police. Where there was a lapse was between the PSC and the appellants.
Well, is there any letter that you can draw to our attention in which the chairman of the PSC was representing to the Commissioner of Police that sufficient progress was not being made in the investigation of these very serious allegations?
Not in those terms, my lord, not in those terms. But we do have transcript of the meetings of the commission to deal with the question of promotion. And I still, the process began as complaint, and then it was overtaken by this request for promotion. And we're going to look at the context in which the issue of promotion arose. But the regulation sets out a scheme and the process by which disciplinary action, disciplining of the police is to be done. And just to say that it is actually the Governor General who has the power and not the PSC. Unlike, say, in Trinidad, where the PSC is vested with the power. The commission...
The power to?
Promote,
promote, no.
Discipline, and hire, yes. It is actually vested in the Governor General, and we have cases where it's not just an automatic acceptance of the decision, because the Governor General can have resort to advice from its Privy Council in dealing with the matters. So it's slightly different in, say, Trinidad, where the case speaks to it.
Could you help on a factual matter arising from the charts that you took us to at page 141, and there's another one at 157. I've been looking at the Court of Appeal's judgment at paragraph 127, where they're dealing with this sequence of events. And I think your submission is that the PSC did everything it could do to investigate and find out what had happened and so on.
In the circumstance.
And we can see in paragraph 127 at 517 in the electronic bundle that they waited at their meeting on the 29th of March 2011, and then they got material from the DPP, and then they recommended the promotion. So trying to fit that timescale into the material that we were just shown in the tables, on the one at 141, that emanated from somewhere in January 2011. It's 141 of the electronic bundle.
Yes, my lady. Yes.
That came from somewhere.
Yes.
In January 2011. And on that, there were 37 matters, and in a lot of cases, the investigation was continuing, or advice was...
And had been ongoing.
Or advice was required from the DPP, etc. The next status update, I think, that you took us to was at 157. This is rulings from the DPP.
147, my lady?
157.
157. But
149.
But may we look at 147 before we go to 157? Yep. It's an updated set of reports.
Right.
In returns in respect of Hewitt, and that was in February of 2011.
Okay. So had everything been concluded? And if so, by whom? The reason I'm asking this is because by the time it gets to the DPP's table, there's a relatively small number of cases on there. And I want to be satisfied that everything which was outstanding on the first table was cleared up by the time of that last one.
Not everything, but they were going through a process. Yes. These were the matters that were referred to the DPP. Right.
So there were still unconcluded matters
It appears.
by the time the PSC decided in April 2011 to recommend the promotion.
But, milady, in order to get a full appreciation of what was being done and the level of seriousness, it may be helpful to just look at what remained outstanding. And then we have also at page 188 another set of reports. Beginning there to page 204.
And where does this come from?
From the BSI.
Summary of it is that how many cases remained outstanding?
By that time, most of the matters, they were different. Police had done most of what they needed to do. Some awaited forensic certificates, which is from the forensic laboratory, in respect of ballistic reports.
And the date of this is?
This report, the date is not. Let's just make a reference to the affidavit, milady. I crave your indulgence. Page 179. Begins at 179, goes on. I crave your indulgence. At page 184. Starting at 183, that notwithstanding the paucity of information relating to alleged incidents, a review of the files at the BSI archives was undertaken, and I observed and was able to conclude that based on the information supplied by Jamaica for Justice on its list, Senior Superintendent Hewitt was not involved either directly or indirectly in some of the incidents. In some instances, he acted in the capacity as commanding officer of the area in which the incident occurred, and that no Senior Superintendent Hewitt would have been notified of the incident and would have visited the location personally. So sometimes it had to do with his going on the scene that his name was called, not that he was.
I'm really talking at a greater degree of generality than this. How many matters remained outstanding by the time of April 2011?
At that time, outstanding in terms of for final rulings?
Yes, investigation not concluded for one reason or another.
I crave your links.
But maybe you can't answer it straight away, but perhaps in due course.
Well, most of them had been dealt with. Most of them had been dealt with. There were processes in relation to the matters that were referred to the coroner's court for which a hearing was to be held. But insofar as the investigations had been concerned, most of them were already dealt with.
Well, don't trouble with it now.
Understood. So again, contrary to the picture being painted, that here was a decision to be made. No investigation had been done, no steps taken to inquire into the seriousness of the allegations and the role of the SSP. The evidence paints a completely different picture. And this doesn't mean that there are not valid concerns about the timeliness and all of that, but within the structure of what was available. And information going before the PSC in order for it to make its decision. So then we come to the vacancies. And again, the context in which the advice from the Commissioner of Police to the PSC arose. We go to page 104. And this is new commissioner now in place, moving from acting to being appointed, taking on his duties, making assessment as the operational head of the force under the the Constabulary Force Act. It says there are 24 vacancies existing in the rank of Senior Superintendent of Police in the Jamaica Constabulary Force.
I'm sorry, where are you reading from, please?
Page 104, my lord.
104?
104.
Oh, sorry.
Yes.
This is the letter of the 25th of November, making suggestions about
So this
promotions.
is overtaking now. This
This is where we get promotions coming in.
Yes, my lady. So complaints are ongoing, investigations going, and then the issue of the commissioner making his assessment as to what the needs of the JCF are and what he has to do and what the PSC would have to do based on his assessment. So November 25, newly appointed Commissioner of Police, Ellington, writes to the PSC saying, there are 24 vacancies existing in the rank of Senior Superintendent of Police in the Jamaica Constabulary Force, consequent on the retirement and promotion of some members. The establishment of Senior Superintendent is 38, and promotion to this rank was deferred for over 3 years, resulting in some critical posts being devoid of the required rank and authority. This has also impacted succession planning and training and development for future areas. And the procedure for selection of the candidates for promotion took place June to July. That is, this process now is before it gets to the PSC. There is an internal process, as it is the commissioner who makes the recommendation, and then the PSC would assess. And as part of the criteria for his or her promotion, applicants appeared before a selection panel, a newly established ethics committee. And those who made themselves available for the process were interviewed by 2 panels, and it sets out how the panels were constituted. It says, in an effort to select, over on 105, the most suitable candidates for promotion, I chair the Commissioner's Selection Board, comprised of all 3 deputy commissioners. The board, using the results, undertook as its first task to identify the most critical areas in the force to which the best of the available resources should be deployed. Context matters, the needs of the force, in terms of what is happening, has to utilize the best available resources in order to deal with the most critical areas of the force. And we see among those who were to be considered for filling the vacant positions of senior superintendent was Mr. Hewitt. And if we go to 107, we see Mr. Delroy Hewitt, superintendent, is a hard-working, dedicated officer who leads from the front. He has commanded several challenging divisions and has succeeded in reducing crime. St. Andrew South, his current command, which was viewed as the murder capital of Jamaica. And since taking over, major crimes have been trending down. Some say that Jamaica has the highest murder rate outside of wartime. It is a challenge that we face. That particular division was then described as the murder. It's dealing with just rampant criminality. But tough, no regard for law and order, no regard for the police themselves. Confrontation. Says the figures show that major crimes are down by 19% and murder down by 33%, or 71. The human rights lobby groups are recommending that he be removed from frontline duties. However, he is fearless and prepared to tackle the criminal element in the society. The Jamaica Constabulary Force needs his experience to help in managing crime and violence. He is recommended for promotion to the rank of superintendent. So I guess it's really a balancing act. It's not that the allegations against Mr. Hewitt are given short. It's not that they're being overlooked, but context matters. Where has he been policing? What's the character of these neighborhoods? Confrontations are higher there than anywhere else. If his style is operational and leading from the front, he's going to be on the scene. Evidence shows even when he's not there, his name is called. Context. And the level of vacancy that existed at that high office. New commissioner in place, is making an assessment. What do I need to do? I have to look at what I have inherited. I have to look at where the greatest needs are in the context of high criminality and high killing, high murder. Who has the expertise? Who is able to police or command police operations in communities where some would say is the wild, wild west? It's really not. Are allegations being overlooked? I would say not on the evidence. Cannot be properly concluded on the evidence. That serious consideration was not given to the complaints. So here now is that context in which the Commissioner of Police writes to the PSC advising of the vacancies. What did the PSC do? Did it do little or nothing as is contemplated by the appellant? It does not say that. December 14, 2010, the PSC meets to consider the promotion. And we can just look quickly at paragraph 28 of the affidavit of the chairman at page 78. Of the bundle. 78 says, in keeping, starting at paragraph 28, in keeping with the policy and practice of the Commission, when the recommendation for promotion of officers, including Superintendent Hewitt, came before the Commission, at its meeting of 14th December 2010, a fatal incident report on each officer was requested before any decision was taken regarding the promotion. So we had gotten, the impression was given that promotions would be considered without looking at complaints, without looking at whether candidates being recommended for promotion had what their conduct was. This clearly shows that contrary to the impression being given, as a matter of course, the PSC would look into fatal incident report on each officer. That would be requested before any decision is taken in regard to promotion.
Well, that sounds like a convenient moment at which to adjourn. It's now 1 o'clock, and we'll look forward to hearing from you further at 2 o'clock. We'll now adjourn.